Thank you very much, Sonia. Thank you for a wonderful introduction. So, with your permission, I will share my screen. Shall I share my screen?
Yes, sir, please do. I think.
Yes. Uh, is my screen visible to everyone? Yes.
Yes, sir.
Great. Great. So, as I mentioned, what we are going to do today, identify, protect, and how to enforce your intellectual property. Okay. So, So these are a few awards that we have, and specifically today, I'm going to address the problem that most of the entrepreneurs or business they don't want to lose their business to their partners, employees, and competitors. So they always have an internal threat and an external threat. So you don't underestimate the threat that you can expect from your internal team members as well in near future. So how to curtail those threats? I will try to cover everything in this webinar. Okay. To ensure that you don't lose your business to your closest allies and prevent your competitors from using your goodwill. Okay. So specifically, whenever you start a business, initially in the initial phases, no one knows your business, what it is. Once you start earning money, once you start getting goodwill, then people see you as a competition, and they try to snatch your goodwill or your products. Okay, so that is how people will get an inspiration from your business, and they will try to do something that you are doing, and that becomes a problem. So most of the companies that came up with innovative ideas, the first company that came up with an innovative idea has always failed, because those innovative ideas were so attractive that people saw it as an opportunity. With larger fundings, with larger capacity, other companies took it over very easily. Okay, so to avoid these kind of things to happen to your company, intellectual property is the only asset that can prevent this kind of competition. Okay, so what is intellectual property? So intellectual property is anything that is created from your mind, and when it is protected, it becomes intellectual property. Okay, unless and until you protect it, it does not become intellectual property. Just make a note of it. So anything that you identify as an intellectual property, you have to protect it, otherwise it will remain open to all, and there may be a problem in near future. Okay, intellectual property is an important tool used to protect and enforce the right of inventors, creators, and businesses. It can be used both as a weapon and a shield in terms of protecting one's ideas and creation from being misused or copied without permission. As a weapon, it can be used to take legal action against those who infringe upon the rights of the intellectual property owners. As a shield, it can protect the owner's work from being illegally used by others. Okay, so any business, whether it has innovative products or not, but definitely they will have an intellectual property rights. And if you don't have protection on intellectual property rights, it will be an easy walk for your competitors to copy it. Okay, so like other assets, intellectual property is also one of the biggest asset that company owns. Okay, so generally in foreign countries, if you see, there was a takeover of Motorola by Google initially, and then by Lenovo. So do you think that Google took over Google took over this Motorola company for their physical assets? The answer is no. They took over this company so that they can own their intellectual property, specifically patents. They had 17,000 patents, which would enable Google to manufacture the mobile phone. Without these patents, they were not able to manufacture it. So in foreign countries, and this trend will percolate in India as well, that valuation of the company will depend upon intellectual property. Okay, so there are few examples I can give you. Like in the Indian market, you don't see any Indian mobile manufacturers. There are very few mobile manufacturers, or I can say no mobile manufacturers. So there was one company that was manufacturing mobile phone in India. So anyone knows the name of the company, which got shut down in 2015 or 17, somewhere around? Any company you know? Indian one. There was only one company. Lava, okay, I think Kodak. Kodak is a what I can say. They are into photography. Kodak is Micromax. Yes, Gaurav is right. Micromax. And there was one more company, Ericsson. Do you remember? Anyone has used that Ericsson mobile phone, which has good quality sound nowadays? Do you find Ericsson mobile phones in the market? Sony Ericsson, right? It was Sony and Ericsson collaboration actually, right? So now these two manufacturers are not there in business, or they are not manufacturing and selling the product. Motorola has stopped their business. They have come up with their own new version, small version. Once upon a time, they had 28% of market share. Micromax had 28% market share in India. But due to litigation and few other factors, they had to shut down their business because Ericsson had few standard essential patents which they were forced to license, and that is where the profit margin of Micromax reduced substantially, and also due to some other factors they had to close down their business. Okay, so this is the strength of intellectual property. And even if you see in India nowadays, till date I can say 70% of the patents that have been filed in India, I'm a little optimistic. It is more than 70%. It is 75 to 80% of the patents that have been filed in India are by foreign entities. Indian manufacturers are still not serious about protecting their inventions. The only thing that they find is cost-effective product with reasonable quality. Most of the Indian manufacturers don't focus on high-end, high-quality product. You name a company, I will bet this is applicable to all Indian manufacturers. But if you see the recent company that has rised like anything, Oppo is giving good competition to Apple also with respect to your technology. They are competing directly with Apple, not even with Samsung. They have so high tech innovations with them. Okay, so this is an asset. So intellectual property is an asset. In near future, getting the product manufactured from a vendor would be easy, and today also it is very easy. If you see Boat as a company, everyone knows Boat. Everyone knows Boat. Just type in yes if you know, and what is their product. What is their product? Boat is well known for what? Headphones. Guru Kiran, yes. Headphones, great, yes. How much percentage of these headphones are manufactured in India? Do you have any idea? They claim to be Indian company. They claim to be an Indian company. Gaurav, zero. Okay, any other suggestions? Literally, Indian government is pushing hard to make sure that boat manufactures at least 20% of their headsets in India. They are importing all their headsets from China. Okay, they are optimizing the cost. This is how most of the companies in India are working. And how many patents do you think they have? How many patents? Just an understanding. How many patents you think they have? And if I just give you a comparison, like JBL, okay, Qualcomm, Sony, specifically on headphones, they have hundreds of patents. Okay, now what I can say, Boat is having more than 20% of market share as of now in the Indian market, but intellectual property they lack in. So it will be an easy walk for their competitors to understand what they are doing and enter into competition. So there are many similar competitors entering into this market, noise, and there are many people. If they get more funding, definitely they can crush Boat anytime because of lack of innovation in intellectual property. Okay. Yeah, this was an update for me from Mohit. Oppo also owns OnePlus and Vivo, so I was not knowing this. Thank you for that. So I will take the questions. If you have any questions, you can just type in the question Q&A section, and in chat section, just give me some answers where I'm asking some questions. So in QA section, I won't miss any of your questions. at the end of the session. Okay, so like other assets, intellectual property also can be bought, licensed, exchanged. IPO owner can prevent unauthorized use, take legal action, take people to attract people to the court, and sort legal remedies. Okay, the only one advantage of intellectual property is it is intangible, means as it is created from your mind, you can create multiple intellectual properties. And even if you create multiple intellectual properties, it won't be exhausted. As an inventor, as an entrepreneur, you can create multiple business ideas as well, or multiple innovations as well. So it is not exhausted by consumption. This is the beauty of intellectual property. Okay. So whenever this is what happens when you develop an intellectual property. So always you identify some problem. For example, there is a Uber, Ola, or Zomato, or any business you see, they're solving some problem that we have been facing, either by innovation or by services. Okay, so whenever you start any business, it's assumed that you are solving some of the problems. Okay, by solving these problems, you get recognition. If you have more patents, valuation also increases. If you have strong intellectual property, you have created a lot of fence around your businesses, then your valuation also increases, recognition also increases. So this is for individual inventors. They can stand out in the crowd if you are an individual inventor and get promotions in your own organization, or get a better opportunity with this intellectual property that you own. Okay. And ultimately, with this intellectual property, you should earn money. If you are not able to earn money from this intellectual property, sooner or the later, you will think that I have wasted my money in protecting my intellectual property, or you will go with the cheap resources and to protect your intellectual property. And in near future, you will see that you are just investing and there is no returns. The only return that you can expect from intellectual property is reduction in competition. People finding it difficult to launch similar services or products in the market. That is the only thing that you can observe. By reducing the market competition, your market share should increase. That is the tangible output if you are a company owner of the intellectual property. You will never get direct revenue unless and until you sell out your business. Okay, so just make a point that whenever you are protecting something, don't expect immediate returns. So returns will happen only when your competitors are not launching similar products or services, and you are able to capture that particular market. So intellectual property, or specifically patents, are supposed to give you 100% monopoly in the market. Okay, if you are not getting 100% monopoly, there is a problem with your strategy, or there is something problem with the work that you are doing. Intellectual property protection that you're doing, there is some problem, so you have to identify that problem. Okay, and specifically, you can, as I mentioned, you can earn only when you see that other people are finding it difficult to launch similar product, and if they are launching, you have to take legal action. That is the only way to increase your revenue. There is no direct or tangible way. Okay. So these are the different facets of intellectual property. So I will cover most of them today. Trademark, copyright, design, patents I will cover, trade secret, IC circuit layout design I have eliminated. Plant variety protection I'm not taking because it may not be relevant. If you have any questions on that, you can ask me in the question answer session, and other agreements that are required. So that also I can cover in the small in brief. Okay. So how to use intellectual property. Okay, so whenever you start, your entrepreneurs already started their business, or if you want to start your business, so one thing that is needed first, yes, definitely you need an idea, you need some problem and some solutions, but for starting a business, what is the first step? Just I want to hear it from your side. What is the first step that you need? Anyone? Am I still audible? Yeah, Cure, correct. Company name. Company name, GST, yes, this will come later on. So first thing that you need is identification for your company. The identity. Today I'm Sunit Savle, that is my identity. For my company's name is Brainiac. Brainiac IP Solutions, that is my company's identity. If I lose Brainiac IP Solutions, it will be difficult for telling you people as well. यार मेरा Brainiac था now I am operating with different name now. Sorry, yeah, that something happened in between. Okay, so it is very important to choose a name that can stay with you perpetually. This is the mistake most of the entrepreneurs make. Actually, they take it as a very casual approach when it comes to protecting their brand name. They see it as a compliance. And just for your reference, 3 lakh trademarks are filed every year in India, which means 3 lakh unique names are being protected. So the competition is high, litigation chances are high. So if your competitors are big companies, in that case it will be difficult. Okay, so just to give you an example, it's a very layman's example so that everyone understands. So whenever you start a business, first name is, this is a chai wala business. So now nowadays chai business is a very trending business. Actually, it's a very trending business. That is the reason I took this example. So tandoor, this is a tandoor chai or a matka chai. So first thing that you do is name it. Okay, so will you get protection on the name tandoor chai, matka chai? The answer is no, because these are the generic names. The process, you cannot have monopoly on that generic names. Anyone can have that tandoor chai and mention it is tandoor chai, because chai to chai ही होगा, तंदूर में बनाया तो तंदूर chai ही होगा, मटके में दोगे तो मटका chai ही होगा. Okay, so on this kind of generic words you can never have protection. But still, if you want to have protection, so what people do is, these are the different combination of names that people come with. So these are specifically name plus logo. It's combined together to protect the brand name. Okay, so MBA Chaiwala. So he has given an abbreviation for it, Mr. Bilair Abad. Okay, maybe it is his name. So this is how we have mentioned MBA, because he cannot have a monopoly on MBA. MBA is a master's in business administration. He cannot have a monopoly on that. So he combined this, correlated with his name, and then made a logo out of it. That is how we got a name for this protection for this device. Okay, so next is Chai Chai by Azad, Chai Bolo Chai, Chai Wala. Chai Wala is specifically with logo. Now there is Engineer Chai Wala. I see a lot of Engineer Chai Wala also nearby my vicinity in Pune. I see that Engineer Chai Wala. There is BBA Chai Wala. So Tandoor, Matka, Chai and Coffee. So this is a label that they have protected. So advantage of protecting a trademark. First is, you have to have a unique coined word. First thing, the McDonald's, so MacD. Okay, so Nike. Okay, so these are the MacD. I'm not sure about MacD, but Nike is a unique name. Adidas. Okay, these are the unique name. They don't correlate with the product itself. Okay, if you are able to have these unique names, it will be very easy to create a brand and establish yourself. At the very initial stage, the Nike had an advantage to have a protection on the tick mark. They have a protection, a separate protection for the logo, that is a tick mark logo. Once you see anything that has that tick mark, you will correlate that ये Nike का product है. Okay, the first choice of yours always should be to coin a unique word where you will make sure that there is no competition happening in near future. If at all you think that I don't want to use unique words, I want to be just correlate my brand with the product itself, like this chai wala. Okay, so there is one more brand in that recently is rising. It's Clear Skin. They are skin cleaning clinic, and they are using the word clear skin. Okay, do they have protection on this word clear skin? No, they have a logo that has been protected. Can someone create another logo and take protection for clear skin? The answer is yes. Okay. The advantage of coining a word is that if anyone comes closer to your words, you can take legal action against them. And if you are using generic words, then you have to combine it with the logo, and then your enforcement capacity reduces drastically. Or people can copy it, and you have to just watch. So you can make a choice based on your business model that you have. But my suggestion would be, coining a unique word should be a priority. Okay. So trademark is a sign that distinguishes the goods or services of a given enterprise and distinguishes them from its competitors. The Trademark Act 1999 defines trademark as a mark capable of being represented graphically, which is capable of distinguishing the goods or services of a person from those of others, and may include shape of goods, their packaging, and colors also. Okay, if you see what I can say, mineral water bottle have unique colors. Okay, those colors are also protected. Even if you see some products, they also have unique colors. Uh, According to section 2M, trademark defines as a mark as a mark as a includes a device brand, headline, label, ticket names, signature, word, letters, numbers, shape of goods, packaging, or combination of colors, or any other combination. So these are the different things that you can protect under a trademark. So device, it's a name plus logo. Brand, it's a tagline or the name of the product. Headlines also you can protect it separately. Okay, apni dukan. Just to give you an example, apni dukan. This is by Amazon. Okay, just to give you an example. Labels, tickets, name, signature. Okay, signature mark. I just to know one signature mark, that is Kirloskar. The Kirloskar brand is recognized by that's the signature of Mr. Kirloskar. Okay, word, letters also 3M, 555. Okay, so these are the different word and letter combinations also you can use to protect your brand. Okay, under trademark. So there are very few um, uh, shape marks granted in India. My voice is breaking. Is it clear now? Is it clear now?
Yes, sir, it's quite clear. It's
Yeah,
just sometimes it's just breaking a bit.
little fluctuation due to internet, I guess. Okay, okay. So, so these are shape of the goods, and okay. So I will just close my camera if that works. Just check. Okay. Is it better now? Yeah. Thank you, Kishore. Okay, okay. So defines so shape of good, as I mentioned, Coca-Cola bottle is the only product that has been protected under shape marks. Recently, the shoes by the name Crocs, the shoes with the big foot and the holes, they tried to protect it, but it was not awarded. That it was not given protection actually under shape mark. Okay, so these are the shape marks, packaging or combination of colors. Okay, these are also can be protected under trademark. Okay, so these are the names. So can you recognize the brands that are been displayed without having their names? Which is first year? Audi. Yes. Next, Jaguar. Then Tata and Toyota. Correct. This is the beauty of brands. You don't need the names at all to identify your products. Once you see the logo, people will understand. So name plus logo is a device mark. So there are other non-conventional trademarks that also can be protected. In India specifically, there are few marks that are allowed. So color marks, yes, color marks are allowed in India. So you can protect color of your product, specific grade of your product. Second is sound, specifically if your product is correlated with some sound, there is a music that is when you hear that music, you can correlate with that product. Like there are ringtones of mobile phone. If you have Apple phone, there was a specific tone. Nokia earlier, there was a specific tone. Okay, now if you see the vehicles that are being sold in the market, every vehicle is sounding different. Their horns are different. With horns itself, you can specifically understand that ये Toyota आ रहा है, ये Hyundai आ रहा है, या some other vehicle is coming. Okay, so sound marks also can be protected. Okay, smell, as if now in India smell marks are not allowed. Okay, shape marks yes, holograms yes, motion mark yes. Okay, specifically if you see how many of you were watching Tom and Jerry cartoon? Tom and Jerry, how many of you are from my era or young people who are still watching Tom and Jerry cartoon? So what was the production house name? Tom and Jerry cartoon. MGM production, right? And there was a lion roar. So that was also protected under trademark. Okay. Shape mark is the shape of your product that can be protected. Holograms, if you see, there are holograms that are given to identify your product. Holograms. Okay. So those holograms also can be protected. Motion marks are GIF images or some videos that can be protected. Okay. So this is how it is. Okay. So just to give you an understanding, the valuation of the brand. So if at all you think that I want to buy Tata Consultancy Services, TCS brand, so it is $45 billion value. Okay, HDFC $32 billion, Infosys, Airtel, Asian Paints $15 billion, State Bank of India, and this list goes on. So this is the valuation of the brand, not their services. So if at all they want, they can sell TCS only at $45 billion and still continue to do whatever they are doing. Okay, that is the value of this particular brand. Okay, so there are other marks that are called as well-known marks. Okay, so these are normal trademarks and there are also well-known marks. Well-known mark means you have protection in all 45 classification. Based on your products and services, the trademarks are categorized into 45 different classification. So there is a possibility that there are two Brainiac is protected in different classification for different products. There is a possibility because we are into intellectual property services, legal industry and consultancy services. We have protection there itself. Okay. But if I have protection in all 45 classification, it becomes a well-known mark. Okay. To give you an example, if you want to start a business by naming Tata, by using word Tata Salt. Okay. Now you want to start Tata mobile phone. Will it be possible? The answer is no. Okay, so there are few marks that are recognized as well-known marks, and now you can also file for well-known marks. Now there is an opportunity given by the Indian government that you can also file well-known marks on your own. Earlier this was not there. To file a well-known mark, what are the requirements? The knowledge or recognition of that trademark is relevant in the relevant section of the public as a result of promotion of that particular trademark. Okay. It's relevant in the particular section of the public due to promotional activity. Duration and extension of geographical area of the use of particular mark. Okay. Extensive use of particular trademark. Any promotion including advertisement, publication and presentation of this trademark has to be there. And fourth and the last thing is there has to be history of enforcement of your trademarks. Means you must have enforced your trademarks, you must have taken legal action against the people who are misusing your trademarks. If you fulfill all these criteria and if your trademark is registered at least in one classification, you can apply for well-known trademark. Okay, the cost is very high. Government fees itself is 1 lakh rupees and consultants like us may charge you something around 50 to 1 lakh rupees additionally. Okay, because it requires a lot of compliance. So this you can think if you think it is relevant for your business and you want to have domination in entire 45 classification. Okay. So what is a good mark? Good marks are distinctive, very much distinctive. It is very easy to distinguish. Second is capable of graphical representation, easy to speak, spell and remember, invented or coined word. Okay, these are preferred trademarks. Bad trademarks, phonetically similar marks. Phonetically means someone has Cotton Kings. Now I will change the C and put it K. Okay. Now boat hai, so I will make it road or whatever it is. So it is again phonetically similar. Changing the spelling, added one more letter. Okay, these are some kind of misuse of a trademark where you're trying to use the same goodwill of the particular person and represent as a different product. So phonetically similarity is also second most important thing that you need to look into whenever you are protecting your trademark. Geographical names should be avoided. Shimla chai, for example, Darjeeling chai. Okay, so Darjeeling chai, you cannot have protection on that. If you're using Darjeeling, that won't be protected. You can come up with something different. Okay, for example, some products are well known for the geography. In specifically Pune, we have Puneri Pagadi. Okay, Kolhapur Misal. Okay, then there are many things. So you cannot use geographical name. You will not get protection. Some people have idea of using Bharat, India in their names. So they will not grant protection for that. If you're coming up with a device, you can get it. But when you have a device, someone can again use similar name. Okay? Something that is praising your products, not allowed. But if you want to go and combine it with the logo, yes, it can be. Deceptive trademarks, specifically as I mentioned, by changing the spellings, those are not allowed. Okay, so these are the absolute grounds of refusal for your trademark. So these are the things that may cause refusal of trademark whenever you are applying. Non-distinctive character incapable of distinguishing goods and services, indicating quality or descriptive character of the mark, marks customary in current language, generic name, marks common to trade. Okay, just like I mentioned, matka chai, it cannot be protected. It is difficult to protect. Okay, marks deceiving the public or causing confusion, marks likely to hurt religious sentiments. This is also very important. Anything that may hurt anyone's religious sentiments, those are also not allowed. Marks with scandalous or obscene content, specifically in India, they are prohibited. Okay, prohibited under Emblem and National Act. So you are not allowed to use any national emblems, Indian flags, or any emblems that have been used by the government. So those are not allowed. You can use it, but you cannot have a monopoly. You can use your use our Indian flag in your trademark, but will you get protection? The answer is no. Okay. The shape of good is function or necessary to obtain technical result, or shape giving substantial value to the goods. These are not uh, allowed. Okay, relative grounds, mark is identical with earlier marks, and goods or services are similar. Okay, even in the same classification, if the goods and services are different, still you can opt to get protection, because you are distinguishing in the particular class itself that this guy is selling these products, I am selling these products. There is no conflict. Okay, mark is similar to earlier mark, and goods and services are identical. In that case, it will be difficult. Okay. So advantages, TM, whenever you file a trademark, you are allowed to use TM in superscript. When you apply, then only you are allowed to use TM in superscript. Otherwise, it's a crime. Just make a note of it. Okay. So it's not a criminal offense now. With the new amendments, all intellectual property is withdrawn from criminal offenses. So now no one can take criminal action against infringement of trademark, copyright, patents, and designs. Earlier, people were misusing intellectual property. They were directly filing FIR, and people were taken under custody earlier for the infringement of trademarks and copyrights, even for patents, which is not a criminal offense. But now uh, it's not the infringement of IPR is not a criminal offense. Okay, so TM, you can use it when only when you have a applied trademark, or when it is registered. Okay, so these are the rights. Everything remains same for all intellectual property assets. Exclusive use, restrain others, initiate infringement proceeding, prima facie evidence of validity. Okay. Term of trademark, it is 10 years once you file a trademark application. If it is registered, you get 10 years of protection, and before expiry of 10 years, you can renew it perpetually. So this is the only facet of intellectual property that can go from one generation to another generation. There is no end to it. Okay, all other intellectual property has a limited shelf life, but this does not have. You can renew it perpetually. Okay. Next is foreign filing. So foreign filing, protecting your particular mark in India, I have covered. So similarly, if you have business in other countries, so it is also important to protect your particular trademark in other countries. Otherwise, litigation in other countries is expensive. Okay, it's expensive. Okay, so I think, am I audible clearly? Just type in yes if I'm audible.
Yes, sir. Yes, sir.
Yeah,
You're
great.
audible enough. Yeah.
Yes, yes, yes. So, if you have business in other countries, you should protect your trademark in other countries as well. By protecting your trademark in India, it does not mean that you have protection in other countries. So many people assume that India में trademark हो गया तो worldwide protection मिल गया. नहीं, it has to be protected in multiple countries. Madrid system is one of the system where you can use it to protect in multiple countries. This is only a system where you can reduce the cost. Okay, one single application, file it. If there is an examination, you have to hire a local attorney. Otherwise, there is no need. The central application can be directly granted as well. So this is one system that you can use to reduce cost on foreign filings. This is called Madrid system. Okay. Otherwise, you need to file your particular trademark individually in every country. So this is how the trademark applications are processed. So once you file your trademark application, you can write TM. So it will go through initial scrutiny and then it will be published immediately on the website. Then it goes through examination. Okay, examination, you will get an examination report and you have to respond to this examination report within 30 days. If at all the examiner is convinced, he will register it or there will be a hearing. Nowadays it is an online hearing, so there is no need to go to the trademark registry and attend this. During the hearing, if everything goes well, it is again accepted, otherwise it will be rejected. Okay. Nowadays they are not giving multiple chances for hearing, but in worst case, the examiner may give you multiple hearings in worst case. Okay, and then it will be registered or it will be refused, and then you have to renew it before the expiry of 10 years. So I'm sorry, it's not a criminal offense now. This is an old presentation. Okay. So just answer one question before we move ahead. So whenever you start a company, what is important? First to protect the trademark or first to register your company? So what will be the preferred step? There is no private versus public intellectual property. Intellectual property that is not protected is public. If you protect it, it becomes private. Yes, the first step would be to file a trademark. Make sure that you have a trademark coined word in place. If you get the trademark, then only go for company registration. If at all you are in a hurry, if you want immediate protection for your name, so at least get a authentic search done. First is whether you can get a trademark. That is one thing that you need. Second is whether you will get any infringement suit from any third party. So these two things you have to check before registering a company. Company registration is an easy process. They don't check similarity that much. If the combination of words are different, they will register your company. If any word from this combination of word is protected under trademark, you are bound to get a litigation action, infringement suit from the infringement notice from this particular competitors. Okay, so make sure that first is you protect your trademark or get a clearance search for validity, whether you will get a registration, and second thing is whether you will be getting any infringement suits, infringement notices for your trademark. Okay, so this is how you should proceed. The first step would be to find the word, unique word, if it is possible, then go for trademark search, then trademark registration, and then company registration. These are the preferred ways. Otherwise, company register ho gaya, infringement aa gaya. So what happens is after 1 month, if you get an infringement notice, it's okay. You registered a company and within 1 month you got a notice. Very good actually, because in 1 month or 2 months you are not established your business, you have not done extensive marketing, it will be easy to withdraw and register your company. Imagine you are an established business for 5 to 6 years or 10 years now, and then you are getting an infringement notice for someone's trademark which they are using before you. After 10 years, if at all there is a possibility that you are losing this particular trademark, all your investment on marketing, all your investment on branding, all will be wasted. And then you have to come up with your new mark and make it known to everyone again. Okay, it's very much difficult to do what Elon Musk has done with Twitter without paying anything. It was in news that Twitter has been changed to X, right? So it doesn't happen with other businesses. Okay, so this is what with respect to trademark. So next is dress. trade dress. Okay, so trade dress also can be protected. This is another facet of intellectual property. So if you see the construction of the vehicle, the color, if you enter into barista, Starbucks, or even if in MACD, you will see it's the same combination, same interior. Okay, if you see John Deere car, vehicle also, there is the same color combination. So this trade dress also can be protected under trademark. Okay. So these are a few examples of trademark infringement with respect to trade dress. So we'll not go into much details of it. So next is copyright. So copyright is a right given to the creator. So I'll not take much on this copyright because that won't be relevant for many people. Just I will cover and just we'll move ahead. Okay. So copyright is a right given by the law to the creator of literary, dramatic, musical, and artistic work and producer of cinematographic films and sounds. A bundle of rights including rights of reproduction, communication to the public, and adaptation. Means translation rights you have what I can say adaptation rights. For example, if I am producing a movie from a novel, still I have a rights. Someone wants to translate my book into some other language, still I have the rights. So this is a bundle of rights. Is it applicable for businesses? Yes, it's applicable for business as well. Okay, it is very much applicable. So in business, what are the things that you can protect under copyright? Website, brochures, blog, your standard operating procedures, presentation softwares, advertisement content, books, videos, engineering drawings, video, songs, movies, animation character that are used for your business. Okay, so one beauty of copyright is even without having a copyright certificate, still you can enforce it. Means there is no mandatory requirement to file a copyright application. If you are able to establish the date of publication of your unique work, and if someone copies that unique work, you can still take a litigation action. This is advantage. What is the disadvantage of not protecting it? When you approach court, they will not assume that you are the owner. They will investigate the matter first, whether you are the original creator or the other person is the original creator. And then the case will be decided. If you have a certificate with you, copyright certificate, in that case, at least injunction orders will be given against the third party, infringing party, till the court decides this case. Otherwise, the court will investigate who is the original creator. So these are the advantages. So there is no mandatory requirement to protect it, but definitely if you protect it, you will have little better advantage. Okay. The protection term is 60 years for a company or institute of a non-individual person. And if you're an individual person, author, it's 60 years plus your lifetime. Your lifetime plus 60 years. So again, these are the infringement actions that you can take. So it's a criminal offense. It was a criminal offense. Now it is not a criminal offense. Okay. So moving on to next facet is patents and design. So before moving ahead, do you have any questions on trademark and copyright? Copyright application not mandatory? Yes, yes, it's not mandatory. It's not mandatory. Without having a copyright, you can still enforce it. That's correct. Business right reserved with the specific firm or person took away by anyone means right holder can file complaint. Business right reserved with specific firm. Yes, the person who files it. If I'm a company, I will take in no objection certificate from the creator, and then I own it. So this is how it is. For example, I have a production house. Someone is writing scripts. Someone is writing songs. So I will get a no objection certificate, and then I own that. That is how it is. Okay, tell me more about software copyright. Software copyright, see source code and object code. These are required to protect your software under copyright. You have to give the source code and object code. That's it. So the procedure remains same. Or on there is an online portal where you can go and register copyright on your own. It's an easy process. If you go through consultants, it will be little expensive. You can do it on your own, but you may fail somewhere in the compliance and that may get a problem. So if you're a business owner, you should work with experts. If you are starting something initially and if you want to save your cost, so you can do it on your own. Time is most important facet of any person. If you lose time, you're going to lose the growth. Could you please elaborate the government fiscal investments for getting patents? Yeah, I will elaborate that. I have just covered trademark and copyright only. Registration process of uh, fees. Yeah, so for trademark, 4,500 in case you are a MSME company or an individual applicant. This is a government fees, 4,500. If you are falling under other category, the government fees is 9,000. So any consultant would charge you somewhere around 5 to 15,000 rupees, depending upon their experience and their capacity. Okay, so 4,500 or 9,000 is the government fees, and from 6,000 to 15,000 is what the professional fees varies depending upon the process. So if your trademark goes through first stage itself, it is registered, there is no examination and hearing, you will save the amount. Otherwise, it will be little expensive. Copyright government fees for literary work is 500 rupees. Cinematographic work is 5,000 rupees. Okay, videos and sound 5,000 rupees, literatures 500 rupees. Consultant will charge you somewhere around 5 to 15,000 rupees, because there is an examination also that needs to be attended. Okay, otherwise you can do it on your own. Ramesh, what is your earlier question? What was your question? So you can type in your question one more time. Can I speak in a voice? I don't know. You can ask the host. I'm not sure. What if my firm name is being used by someone else but they deal in absolutely different material? Yeah, that is allowed. See, there are different categories. So as I told you, Brainiac, I am using this for legal service and consultancy services. There may be something who are into some other services. That is very much possible. If you want to stop those activities, then you have to have a well-known mark. So it's very much possible. Same name used by some other company for different products and services. Yes, it's possible. Can a partnership firm may apply with partner's name to save the cost? You can save the cost. See how comfortable you are actually. If you're comfortable doing that, if you want to share the ownership, it's good. Or you need an MSME certificate. MSME certificate also you can get and reduce that cost. Reimbursement, I will share that examples. So there are a few things that you can go through. Startup schemes, I will explain you in detail. So for trademark specifically and patents, there are startup facilitators, okay, appointed by the Indian government. So if you go through those facilitators, they will charge you only for the government fees. Other activities government will pay them. So you have to pay only government fees to those facilitators, and their professional fees would be paid by the government. But there is a big problem in this startup scheme, because the consultant that are registered with this scheme, or the facilitators, they are not being paid regularly. So it becomes a problem. And also when the projects are a little complex, these people overcharge you. Sometimes they will add some cost and it becomes difficult. So if you're an entrepreneur, your choice should be to make sure that you are working with the best company, whether they are registered with the facility startup scheme or not. But if you lose on something in the intellectual property, it will be an expensive setback for your business. Okay. For registration of trade, we needed a attorney compulsory. No, no, no. You can do it, Mohammed Saif. You can do it, but as an uh, as a businessman, I would not recommend. If you are doing it on your own, do it. It's possible. Yes, partnership can do it. In that case, can I register my name with my activity? Yeah, Mr. Govind, you can register your name also. There is your name, definitely it will get registered. No one will object you or stop you from using your name. But if there is some other person with the same name, he can also use it. So preferably, if you ask my recommendation, I would say that avoid using your names, because there may be some different people with the same name and they can also use it, and then it may be confusion. Okay. So with this, I think we have exhausted with the question, and I will move ahead with the patents and trademark, patent and design registration. Shall I just type in yes, or I will move on?
So please do, because then in the question answers round, if somebody would like to ask some more, and then I think they'll get some time.
Yeah, 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 sure, sure, sure. Sorry. So next is patents. So patents is the second valuable asset of any company, that any company can have. So all businesses can have patent. The answer is no. Can all businesses have trademark and copyright? The answer is yes. Okay, so patents are only applicable when you have a unique product. Even if you are a vendor, you can have a unique product. If you are just a vendor who is working on OEM's specification, in that case you don't need. But if you want to start your own production, you should have a patent. So what is a patent? Patent is a statutory right granted by the government in exchange of complete disclosure of your invention, and the protection is offered for a limited period of time, that is 20 years only. Okay, the patent cannot be renewed beyond 20 years. Okay? So specifically, there are three requirements for getting a patent registered. The first is your invention should be new globally. Your invention should be new globally. So most of the inventors assume that I have seen a product in US, Europe, or somewhere else, and in India I am the first person. Will you get a patent? The answer is no. Are you allowed to manufacture? It depends upon the freedom to operate search, whether the person has the person who owns the invention has protection in India or not. If they don't have protection, you can copy the product with different dimensions and different outlook, but you won't be getting a patent. So novelty is worldwide. Even if you're filing a patent in India, the patent office checks whether your invention is globally new. Otherwise, it will be rejected. So this is first requirement, novelty. There's another requirement, that is inventive step. Even if your invention is novel, it should not be obvious to a person skilled in art. Okay, this is a second requirement. Okay, so even if your invention is novel, if it has some new features, okay, and if those features are obvious, just to give you an example, if I'm attaching two plates together, earlier I was using rivets, and now I am using nut and bolt. The earlier person never mentioned that two plates can be attached by nut and bolt in a engine specifically. So now, as an engineer, we know that nut and bolt and rivets do the same work. Now there are also adhesives. If this kind of modifications are there, it's an obvious modification. So this is simple example that I can give you. Next is, for example, lipstick and glue stick. Lipstick and glue stick, same mechanism. Okay, the glue stick came recently with the same mechanism. You just have a screw mechanism. The content will pop up and you can apply it. What is novelty in this? The glue, which is more viscous now, that is novelty. The mechanism doesn't have any novelty. Okay, so these are some example. On case to case basis, it varies. You have to take a expert opinion on an inventive step. Novelty, definitely you will be able to understand. If it is same, it's not patentable. If it is different, you have a scope. If you say the invention is same, scope is gone. If you say your invention is similar, still you have little scope of protection. So third is industrial application, specifically in India. If your invention is capable of is capable of being manufactured by the industry or used by the industry, then only you will get protection. Otherwise, no. Okay. So what can be protected? Product, process, composition of matters, machines, and improvement. These are the things that you can protect under patent, provided you fulfill all three requirements. Not all inventions are patentable. Specifically, scientific discoveries, scientific principle, business methods, softwares, traditional knowledge, these are not patentable. So specifically, scientific discovery like gravity is a scientific discovery, speed of light is a scientific discovery, principle like E is equal to mc square, these are not patentable. You cannot have a monopoly on this. Okay, even if you're coming up with some mathematical calculation, those also cannot be protected. Business methods, like specifically Amazon and Flipkart, they're doing same business, right? Delivering product to your doorsteps through an online portal. You can select the product. Their UI is different, their offering is different, the structure is different, but they are doing the same thing. Is there any protection on that? No. Swiggy, Zomato, same thing. Okay, Swiggy has recently started with one more services like Dunzo. Okay, so that is the reason they cannot be protected. Mere software. So Microsoft Excel is a mere software. Word document is a mere software. Any software that can run on any hardware which does not have technical output cannot be protected under patent. If you are able to prove that your software has technical advantage, definitely it can be patented. And patent is more stronger than copyright. So you can get copyright for the source code and object code, and for the way it is operating in the use of hardware, the way the problems are being solved by using the software, you can also have a patent. Traditional knowledge like turmeric, neem, these are used as an antibiotic. So those things cannot be protected again. Okay. So this is a general process of trademark patent followed by the Indian Patent Office. So either first step is you have to conduct a patentability search first. So your first step should be always to conduct a patentability search and then go for filing. If you don't have time, if you want to launch a product immediately, at least file a provisional application. So after filing provisional application, you get 12 months of time to file a complete specification. But if you think that your product is innovative, first thing you have to do is file a patent application and then only go into market. If you sell a single product, and if your competitors are able to establish that before filing a patent, you have sold a product in the market, there is evidence of invoice, your patent can be revoked because it is a willful destruction of novelty in exchange of money. So selling, you should not do before filing a patent. Just make a thumb rule. After most of the times, what happens is after selling, after launching a product, once people like it, and now you are seeing there is a rise in competition, then people think of protecting it under patent. That's a very wrong strategy. It will be an investment for your business. Just make a note of it. Patent it before launching a product. So you can file a patent as a provisional or complete. Complete, if you file it, there is no scope for modifying the product document later on. So once you file a patent application, it goes through internal scrutiny for compliances. If your invention is related to defense technology, it may not be published, or it may be on hold. They may take more scrutiny. Okay, that may happen. Thereafter, classification is allotted. Classification is allotted so that your patent application is examined by the person who is from your technical domain. Okay, and then it goes for publication. So normally the patent application gets published after 18 months, but it can be preponed by filing a request for earlier publication. So once your patent is published, there is a possibility that third party can take pre-grant opposition. Okay, there is a possibility. Not all patent application gets this opposition. So you also have to file request for examination. Request for examination deadline is 48 months. If you miss, again your patent will be abandoned. After filing request for examination, then only a patent application gets in the queue for examination. So if you file the request later, there will be delay in grant. If you file it earlier, at least on the date of publication, your patent application will get examined earlier. So within 6 months or 48 months, within 6 months or 48 months, your patent application will be examined and you will get an examination report. 6 months in case you are applicable to expedite route, if you are eligible for an expedite route. So I'll explain. You get 6 months of time to answer this examination, and if at all the examiner thinks that still he has some queries, okay, in that case he may raise an hearing for your patent application. Again, it is an online hearing, and then it will be accepted or it will be rejected. If it is rejected, you can challenge it in the High Court, and if it is granted, you have to pay yearly maintenance fees. Okay, yearly maintenance fees is required to maintain your patent. It is patent is most expensive facet of intellectual property when it comes to professional fees. So generally, the cost is somewhere around 1.5 to 2 lakh rupees professional fees, including professional fees. Government fees are very less. If you want to do a patent application on your own, the government fees are somewhere around 10 to 15,000 rupees if you are an individual applicant or MSME. If you are a large company, the maximum fees would be somewhere around 28,000. Okay. So these are the fees. Apart from that, all are professional fees of the consultants or agents or attorneys. Okay. This is the most expensive part of intellectual property. Similarly, I am just giving you a glance of how US patents are processed, because most of the value come from US patents only. People have maximum valuation coming from the US patents, not from Indian patents, because Getting in investors in US is much easier in comparison to India. Valuation of the products are much higher in India, in US, because their US people are willing to pay more for high-end products. That's not the case with India. Okay, so till publication, everything is same. Request for examination, office action, answering office action. They call it office action, we call it examination. That is the difference. And again, rejection, grant, and they don't have yearly maintenance fees. They have three maintenance fees only after completion of 3.5 years, 7.5 years, and 11.5 years. That's it. Okay, so that is the difference. And if you compare the cost, it is 4 to 5 times higher than Indian patent cost. So just for filing, you would be investing somewhere around 2 lakh rupees in US. Okay, specifically in Europe, the government fees are itself around 4,000 to 5,000 euros actually. So it's the most expensive facet of intellectual property. Contents. So these are the contents. Just I will run you through: title, field of the invention, background, prior art, relevant citation, objects of the invention, summary, brief description, drawing, detailed description, claims. So claims are the content of the patent application that gives you protection. If the claims are drafted in a correct way, your protection may be good. It can increase the valuation of your product, your patent, or it can decrease the valuation. So claims will decide whether the fence that is created around your invention is strong or weak. Okay, if it is strong, the valuation rises. If it is weak, valuation decreases. So that is the reason this is an expensive affair. So that is the reason people charge on a very higher side for patenting. Okay. So just want to cover strength of patents. So just to give you an example. So how many of you are from this technical background, or how many of you need more information on patents? So my voice is breaking again, so I will stop my video. Fair enough. Okay, I have seen Mohammed Saif. Okay, Govind. Okay, so specifically, first most valuable asset is trademark. Second, patents. Okay, the highest value of your business comes from trademark and then from patents. Sometimes people may not opt to take your brand, but they may need technology. Just to give you an example, Nokia now has 5,500 patents on 5G. 5,500 patents on 5G, and they are licensing their technology to all mobile manufacturers. Initially, they had a legal suit in UK and Germany. They had banned Oppo and OnePlus in Germany, and now they are having a licensing agreement with them. And already, iPhone, Apple has already surrendered and took license from Nokia. Okay, so this is the power of patenting. If you have standard essential patents, everyone will surrender to you. That's the beauty. And it does not happen with one or two patents. If you have to have a fence of patenting. If you are able to create a fence around your invention in such a strong way that I have a problem and I have patented all the solutions for this particular problem. In that case, if someone wants to launch similar product, someone wants to solve some problem and launch similar product in the market, they will have to come to you. So one common mistake that every person does is they identify a problem, they identify a problem, they solve the problem in their own unique way. They assume that it's the best solution that anyone can give. It's like a child. My child is the best. And when they go out in the market, they see similar products are coming in. Or second case, if they want to license their patents or they want to sell their company, most of the people, most of the companies are not willing to pay you money. This is an human psychology. मैं आपको अगर आज के वेबिनार के लिए 10,000 चार्ज करूंगा तो आप नहीं आओगे. सिंपल है. Why? Correct? Extra money. No one is ready to pay extra money. So this is how it is. What they will do is, अच्छा आपने ये प्रॉब्लम इस तरीके से सॉल्व किया है, I will and solve the problem in a different way. Still launch the similar product. So if you have fans like Nokia, like Ericsson, then you can have a monopoly. Otherwise, it give you one example how patent claims can increase or decrease the valuation of a product. Can be used in a automobile. It has suction cups. Okay, it has suction cups and a table or a tray. Okay. So just to give you an understanding, this is how the claims can be written. Your voice is breaking. So just I will move on to some other place. Just give me some time. My voice is breaking continuously. Is it better now?
Certainly, sir, it is.
Yeah, great. Okay. So just to give you an example, a portable shelf that is capable of being attached to an interior portion of an automobile for providing extra space, okay, for accommodating various articles such as cell phone, camera, laptop, and the like. So this is a very simple claim where I'm not claiming any construction. So are this claim good? The answer is no, because they're not protecting anything. They're not able to protect anything. They're just giving advantages. Okay. So next type of claim, when you say that I want to protect the construction of the construction of the product, in that case, people tend to write these kind of claims. A portable shelf is provided that is capable of being attached to an interior portion of an automobile for accommodating articles thereon. The portable shelf comprises a tray, two foldable tubes, and two suction cups. The tray is capable of accommodating the articles. The two foldable tubes are horizontally attached to the portion of the tray, and blah blah blah. So one input I want from your side. First set of claims were not good. I have told you. Are the second set of claims good enough? I'm waiting for your answers. Yes or no? Are they better? The answer is yes. Rajesh has mentioned yes. Anyone says yes or no? Don't know? Okay, Mohammed Saif. No problem. Guru Kiran, better? Yes. Are there any limitation in this particular claim that can prevent or reduce your enforcement possibilities? Are there anything that is not good in this particular claims? Okay, so I will give you one limitation. So now, for example, I removed the tray, and instead of tray, I am using a bowl. Okay, so instead of tray, I am using a bowl or a plank. Will I be able to enforce my claims if someone does that? The answer is no, because I have a limitation of tray. It has to be a tray. Second, two foldable tubes. If at all someone comes up with tubes which are not foldable. Second thing, instead of tubes, they use I section or rods. Are they infringing? No. Suction cups. Third limitation. Suction cups specifically, if I change it with something that is different, I use hook or Velcro or adhesives to attach this tray. It will I be able to take legal action against such manufacturers? The answer is no. So these are the limitation. So preferred way of writing claims, this is one of the preferred ways. It can be better, but I have just given you an example. Okay, the tray word has been replaced here by a receptacle. This is general English word which broadly covers what I am trying to say. Receptacle for accommodating articles. Next is at least one extending member. Now I am not using foldable tubes, telescopically expandable tubes. No, I am just mentioning it as at least one extending member. When I use at least one, which also means that if someone comes up with two extending members, two tubes, three tubes, 4 tubes or 100 tubes, still I have a protection. In earlier claims, if it is 2 and someone comes with 3 or 1, it is difficult to enforce. Okay, at least one. Next is at least one attaching mechanism. Now, attaching mechanism can be anything. It can also be suction cups, but it is not limited to that. So this is how you can increase the scope of the protection. So these kind of claims can increase value of your patent. If the claims are drafted in an earlier way, second type, it can also decrease the valuation of your company and product. Okay. So any questions on patent? If you have, just we will complete everything and then we'll have a question answer session, I guess. So I will move on to the next section, that is industrial design. So industrial design registration, specifically design registration, we call it in India, and in US it is referred as an design patent also. So these two words you can just be correlated: design registration, design patent. It is one and the same. Okay. So any product which is aesthetically new, any product that is aesthetically new can be protected under design registration. So anything that is visibly distinctive. Okay, like all your mobile phones. If you have a mobile phone from a different manufacturer, even if it is rectangular, if you place it one beside each other, you will see there is a difference. Similarly, with the automobiles, similarly with your headphones, with every product you will see the internal mechanism is same, but they have made the looks differently. So this is what this is specifically to applicable for design registration. So can you have patent and design? The answer is yes. If you have aesthetically modified product, you should always have design registration also and patent also for the internal technology. Okay. Term of design protection is 10 plus 5 years. Total protection is 15 years. It cannot be extended beyond 15 years. It is cost effective. It is easy to apply. Only figures and statement of novelty is required. Okay. Within 6 months, you can expect a certificate. Okay. Within 6 months, you can expect a certificate. Or in patent, it may take 3 to 4 years of time. So that is easy to get, right? Less time, and you can start enforcing this immediately. Okay, so this is one of the examples. If you see these examples, everyone is selling mineral water bottles, but the bottle's shape is different, the color combination is different, the color grades are also different. Okay? This is just an example of mobile phones from 3 different manufacturers. Okay. Samsung, Nokia, and Apple. So more or less rectangular, but when you place it one besides the other, everyone will look different. Okay, even their camera position and the screen construction of the screen display is also different. Okay. Design infringement is again a civil suit. Okay, so so these are the few examples. Next is IC circuit layout. So topography of IC circuit can be protected under IC circuit layout design. So there are very less applications that have been filed in this particular category. So you can think about protecting it. Otherwise, you can skip it. Okay. The most third and last most important facet of intellectual property is trade secret. Okay, most of the companies think that they don't have trade secret and there is no importance of trade secret in their business, but every company has some trade secrets which are unique. That is how your products and services become unique, specifically in service industry. So trade secret is any practice or process of a company that is generally not known outside of the company. Information considered as a trade secret gives a company an economical advantage over its competitors and is often a product of internal research and development. Okay. So what can be protected for a company? Formula, patterns, compilation, programs, compilation of data, program, devices, methods, technique, processes, and most important is your customer list. If your partners take away your customer list, prospect customer list, you will lose the entire business. Same is with the manufacturing process. So nowadays it is very easy. I want to manufacture a high-end mobile phone. What I do, get the person who is working in XYZ company, hire him, pay him 10x salary, he will do it for you. Okay, if there are no patents and all those things. Okay, so those kind of trade secrets are very important. So there is no law in India to protect trade secret separately. So it has to be protected under general agreements only. So non-disclosure agreements, non-compete agreements that you can sign to protect your trade secret. So government schemes, I will just tell you. So specifically for startups, there are various schemes of government. So there are fundings available by the Indian government. If you're a startup, 75% of your investment on intellectual property can be reimbursed. Up to 20 lakhs you can spend on patenting, and 75% will be reimbursed to you. Okay, there are few other schemes where if you have a granted patent, they will give X amount, 25,000. If you have a granted patent in other countries, they will give you 2 lakh rupees. So these kind of schemes are available. Okay, specifically for startups, MSMEs, and female inventors, female applicants. Okay, startups, individual female applicants, and MSMEs, and schools and colleges funded by the government, you can opt for expedite examination for patents. You can opt for expedite examination for patents. This is not applicable for male applicant or larger companies. These two entities are exempted from expedite route. Like facilitators for trademark, there are also facilitators for patents. Okay, so all the work apart from searching will be done by these facilitators. You have to spend zero amount on these people, and they will be reimbursed by the government. You have to just pay government fees. But I would not recommend to go with this facilitators, because government is paying very less amount. Instead, you go ahead and spend up to 20 lakh, get an effective patent, and get 75% of the amount reimbursed. That would be the best recommendation from my side. Okay. Apart from that, there are other schemes where you can borrow money from the government, so that you can check with company secretaries. So those people will help you in getting this kind of funds. So company secretaries are the right people to get funds from the government. Facilitators for patents and trademarks. Okay, reimbursement of 75% expenditure up to 20 lakhs from the government for startups. Okay, these are the schemes that are there. Okay, so with this, if you are able to do this, you will be definitely successful and you can protect your business. This is just an example. He is not known to me, just to give you, just everyone knows him. That is the reason I have took his picture. From a chaiwala to a celebrity, it takes a hard work, it takes determination. There are a lot of factors that are required to reach that success. Is it possible? Definitely yes, it is possible. With this intellectual property protection, your journey will get little smoother. That's what I can claim. Okay, just to give you an understanding, so I will not go with this. um, so this is one portal that we have, actually one of its kind in India. So we have a portal for licensing patents and designs. So if anyone is interested, they can visit this portal, ipbasket.com. This is the only portal in India where you can showcase your products, patents, and designs, where people can approach directly if they like it. So that's it. I am open for question answer session. So
I think I like to request Mr. Mohammed Shafi. I think he had a lot of questions to ask. If you can unmute him, Karthik. And Shafi ji, you can ask your questions now, like you wanted to be verbal.
So I have a doubt.
yes, please.
Sir, I have applied for trademark. For example, I have made application asking name of refusal on very first. For example, I'm telling.
Your voice is
Shafi ji,
cracking.
you're not clear. You are breaking.
Acha.
Can you,
I
yeah,
thought
can
it's a
you
problem.
repeat, please? Yeah.
Hello,
Yes.
sir. Am I audible to you?
Now, yes, better.
Sir, that is what I'm asking. I'm filing a application for a name of refusal on January 1st. If
Okay.
someone is going to file application on February 1st with the name refusal, but not like refusal, but they are using refuser by changing a last two words, two
Uh-huh.
letters, I mean, two letters. Can I able to oppose them?
You can oppose them. See, for trademark, user date is also very important. So just by
Okay.
filing, you won't get protection. So there is one more option in while filing a trademark. You can claim prior use. So depending upon the use, you can oppose them. If you have filed it as a proposed to use, it will be difficult. So check the user date and then you can oppose based on the user
Yes,
date.
sir, they have filed after me.
No, filing is one thing. Check user date also. They must have claimed user date also.
What user date, sir? I'm not getting your point. What is
User
user
date.
date?
User date. Date of use from when they have started using it. First
No,
is
sir.
filing.
After I'm using, after that only they have used. They have not yet used the name. Only they have filed the application.
Then you can oppose them, no problem.
Okay, sir. With a lawyer, I can oppose them.
Yes.
Sir, but I'm not having the registration certificate. Is that fine?
Yeah. If you have used, if you have used, if you are able to have proposed that you are using this trademark, definitely you can oppose them, not a problem.
Okay, sir. Sir, another thing. Hmm. So for software copyright, you said, if for example, A equal to 1, B equal to 2, A plus B equal to 3 means, how can someone copyright this type of codes? Because codes are same.
See, there are open source codes that people use generally. If you're using something that is from the open source, you cannot have protection. If you're creating that codes on your own by using some different language or different algorithm, you
Okay,
own
sir.
it.
Okay, okay. With
You
the
own it.
combination of different codes and algorithms, huh?
Yes. I'm solving the same thing, but I can do it in a different way, right?
Okay, sir. Okay. Sir, another thing. Sir, if I'm going to register a trademark in 45 class, but I have missed the description. If, for example, in 9 class, there is a downloadable softwares, but I have not mentioned that downloadable softwares in my description. If someone with the same trademark name can they may able to register the same class with that description?
Yes, it's possible actually. If they are able to prove that they are only into downloadable softwares, and if you are not into that, it is very much possible that you both can get protection.
No, sir. No.
Can we have Atulji? Atulji, please unmute. Karthik, please unmute Atulji. And others also, if you want to ask questions, please raise your hands because we have some time and Suniji is answering each one of you. So if there's any detailed questions, please raise your hands.
Yeah, Mr. Atul, you can go ahead, I guess.
Please ask your question.
Hello.
Sir, you are not audible.
Hello.
Yeah. Okay.
Yeah, sir. My name is Keyur. I had my logo registered as a device of my company name. My company name is Print Plaza. I got it registered in class 35 and 40.
Yeah.
Later on, I already applied for class 16 also, but in class 16 it got refused.
Hmm. Okay.
So I wanted some guidance for that.
So refused means there will be some prior use or someone must be already having a trademark in that particular classification. Maybe
No, no.
reason it has been refused, I guess.
Refusal reason, it is they are conflicting mark. It is showing like that.
That's what. There are conflicting marks. That is the reason it must be refused.
So, what do you mean by conflicting mark, sir?
There is already some trademark that is similar to your trademark.
Acha, but I saw in the whole registry there is nothing like same name Print Plaza.
No, there must be phonetically similar marks. So phonetical similarity you have to check. You check the examination report that must be generated actually.
Okay,
So there are two possibilities. Either you have not answered the examination report. That may be
okay,
one of the reason for refusal also.
okay,
Check what is the status, what has happened actually.
okay, sir. Yeah, thank you.
Bye. Next.
Anita ji,
Yes,
please.
ma'am.
Yeah, please ask your question.
Oh, sir, good evening. As an individual, means Dr. Anita, I have filed 2 patents, and those were granted in 2021 and 2022. Okay,
Okay.
and I have worked on Vitis vinifera, that is a grapevine plant, and
Okay.
these both patents are for microbiology and biotechnology field.
Okay.
So during those submissions, there was a query कि I should submit a permission from a NBA authority.
Correct.
So if this plant comes under the agro crop, then does it was needed कि I should go for NBA authority and permissions and all?
Yes, it is needed because there are no clear guidelines with the National Biodiversity Authority. They have not mentioned which are the crops or plants or microorganisms which we need permissions. So because there is a lack of clarity, what patent office does is, if there is a microorganism, if there is a plant, they ask you to take permission, and based on your application, the NBA decides whether they want some royalty or some profit to be shared. So once you get a letter from the NBA that they need some kind of profit sharing with you, that
Yes,
agreement you
yes.
have to submit, and then it will be granted. So only waste management products now, they are not asking NBA permission. But if your main ingredient is something that is natural, that is very much required.
Okay. And if I want to do some research or some novel work related to some herbal plants, which are already declared as a medicinal plants or herbs. So for that also I have to take permission from the NBA authorities?
No, research, no permission required. Patenting,
No, but I
permission.
want to file a patent for those.
Yes, patent, then yes, permission required.
Okay. And
Permission.
another question I have posted in the QA chat. So can I ask you?
Yeah, please go ahead.
If I want to go for a US patent as an individual applicant, and can I apply directly instead of applying for national patent?
You can file directly in US application, just you have to take permission from Indian government. That's it.
Okay, okay. And being a startup, so can I do same thing for that?
Yes, yes, just take permission from the Indian Patent Office. That's it.
Okay. And what about the fees for both cases?
See, both cases fees remains the same. It is very expensive in US, and you will be spending somewhere around $5,000 at least,
Okay.
because in US you have to go through US attorney only. You cannot do it on your own.
So being a startup, I can directly apply for US patent also, no?
Yes, yes.
So are there any facilities with respect to startup or woman entrepreneur for US patent?
As I told you, as a startup in India itself, whatever you are spending on patents, you can claim 75% as a subsidiary amount, 75% of it. But US government does not have any schemes for Indian startups.
Okay.
So better you go with India and then with foreign companies so that you can claim that money. If you go directly in US, then it may be a little difficult.
Okay. Thank you.
Thank you. Next, please.
Ramesh ji? Okay, Swapnil ji, please ask.
हेलो, मेरी आवाज आ रही है आपको मैम?
हाँ जी, you are clear.
नमस्ते, मेरा नाम स्वप्निल है। मुझे पूछना था, यदि हमें सपोर्ट चाहिए होगा फाइनेंशियली स्टार्टअप के लिए या फिर ऐसा करंट बिजनेस मॉल के लिए, जैसे मैन्युफैक्चरिंग हो, ट्रेडिंग हो, तो फाइनेंशियली सपोर्ट किस प्रकार मिल सकता है जब भी किसी के पास कुछ भी ना हो, ना लैंड हो ना कुछ हो, फर्स्ट जनरेशन से स्टार्टअप करना हो, तो उसके किस प्रकार फाइनेंशियली सपोर्ट मिल सकता है गवर्नमेंट से और कौन से स्कीम में?
गवर्नमेंट स्कीम्स में फाइनेंशियल सपोर्ट आपको,
सॉरी,
स्टार्टअप अगर आपकी कंपनी रजिस्टर्ड है ना, स्टार्टअप एंड एमएसएमई, तभी आपको गवर्नमेंट से सपोर्ट मिल सकता है. सो ऑलमोस्ट अराउंड 1 CR तक सपोर्ट मिल सकता है आपको डायरेक्टली. बट उनके रिक्वायरमेंट्स बहुत सारे हैं. यू हैव टू फुलफिल दैट रिक्वायरमेंट्स. इफ यू वांट, वी हैव सम पीपल हु आर फैसिलिटेटिंग दिस एक्टिविटी फॉर गवर्नमेंट फंडिंग. You can contact us. We will connect you with them. That is very much possible, but it depends upon your case. It is not 100% guaranteed that you will get fund money.
एक्चुअली मैं 2 साल से प्रयास कर रहा हूँ.
Pardon?
जी, काफी समय से प्रयास कर रहा हूँ सर. पीएमएजीपी का मेरे पास सर्टिफिकेट भी है और मुझे सीजीटीएमए से भी चाहिए था, क्योंकि वो गवर्नमेंट से यदि हम लोन में कुछ इश्यू आती पे नहीं कर पाते तो वो गवर्नमेंट पे करती है. तो मेरे पास पीएमएजीपी का सर्टिफिकेट होके भी केवीआईसी का मुझे हेल्प मिली नहीं।
नहीं वो क्या है,
बैंक्स
that is the
कहती
reason I'm
है
telling
कि
you.
पीएसबी लोन इन 59 सॉरी
नहीं, केस टू केस डिफर होता है एक्चुअली. सी किसी किसी
जी
भी
जी मैं ये कह रहा था
गवर्नमेंट को
जैसे
या कंपनी को.
जन समर्थ है गवर्नमेंट का वेबसाइट,
हाँ,
जन समर्थ वेबसाइट है, उसमें सारी सभी सुविधा आते हैं
करेक्ट
जैसे कि सीजीटी एमएससी हो, पीएमएजी हो, मुद्रा हो। जन
करेक्ट.
समर्थ में से मैंने किया था पीएसबी लोन इन 59 मिनट्स। तो
Sorry
बैंक
to
में अप्लाई
interrupt.
करने के
Sorry
बाद
to interrupt, Swapniji. I think this is not part of the session today. These questions. Please don't worry. I'll get you connected, and once we are over, we have few more contestants asking for the questions. तो आप थोड़ा सा patient रहिए.
ओके
I'll get you connected with him in a while. Because अभी
I
आपका
won't be able
question
to
is
answer
not
this
with the
question,
session.
and I won't be able to answer this question also very correctly.
Yeah, because this is not part of the discussion we had today.
Yeah.
So we are sorry, Swapnilji. Is there anybody else? Gunjanji?
Yes, I have a question on trademark.
Yeah.
Yes, please.
The area in which I'm working, sleep solution, there is something called snore owl. So if I put my name as snoring owl, would I be able to get a trademark on it?
See, you have to do a search actually. I cannot give you a blunt
हाँ,
answer yes and a
और
blunt
नहीं,
answer it is no, because both are dictionary words. If you
हाँ,
want
हाँ,
clear answer, it will be difficult. So, but don't take my words. Get a
हाँ, हाँ,
search from an expert and then only
okay,
decide. So,
okay,
yeah,
okay,
okay.
right.
Yeah.
Thank you so much.
Thank you.
I think we have Ramesh ji now. Ramesh ji? Yes, please ask your question, Ramesh ji. Ramesh ji, do you have a question to ask? Please unmute him, please.
Hello, 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 hello. Can you hear me?
Yes, yes. Haji,
Yes.
Haji, Haji.
Yeah, good evening to all of you. It's a good presentation indeed. I run a company, Venica Herbal Products. Basically, it is for hair care and skin care products, external application. I filed for trademark under class 5. First of all, it was objected. Then we filed a clarifications and it was published also. Then later, after 2 months or 3 months, there was an opposition raised by somebody whose name is somewhat similar to my Venica, somewhat. So he raised opposition, and we also again we have given that we are the first users of this name before they started.
Yeah.
And thereafter he did not file a reply also for this. How long I should wait for this?
Generally, you follow up with the trademark registry because
Yes.
what they are in this kind of situation, they just keep these applications on hold. So sometimes it may happen that they will not check because these are crucial applications. They have to put more time.
Can I use TM or R in this
TM,
main?
TM. As of now, TM. Is it registered?
It's published also. It was published.
Registered,
Opposition.
registered. It will be published. तो trademark immediately हो जाता है.
But
Have you used the
opposition was
certificate?
raised later. Later
You have a
opposition.
certificate.
No. Number certificate is there.
Certificate is there, na? Then write R. That not a problem.
No, but then opposition is raised. There somebody raised opposition on this.
You have a certificate or not?
I have certificate.
Then use R. No problem.
OS. Okay. Thank you.
Yeah. Okay.
Shafi ji, you can ask a question, but a quick question because we need to conclude. We're running short of time. So please, can you unmute Shafi ji? Shivi ji, please ask.
So please tell more about Nokia and 5G pattern. You said no for Nokia.
See, 5G patents means they have all patents that are essential for 5G technology. So there are 5,500 patents that Nokia has filed. Because of that, patents worldwide actually, not only in one country. So that is the reason every company has to license their patents, then only enter into 5G market. So every company is licensing. So these are called standard essential patents. So
Okay, so they cannot able to make similar patterns for 5G, like Nokia.
they cannot patent something similar, right? Once you have a patent,
Okay.
other companies cannot patent it again. So they have everything that is there in 5G. 5500 is not a small number.
Okay, sir.
You can
Okay.
just check Nokia 5500 standard essential patents on 5G. You'll get all the information on Google itself. So Nokia
Okay.
5500 patents on 5G.
Okay, sir. Another thing, patent registration is worldwide or only valid in India? If I am registering a patent in India, it is valid for only in India or worldwide?
India.
Okay,
Only-
if someone from US copying my pattern and registering with the US patent office, is it what I'm saying? It is possible to register them?
So if your Indian patent application is published, then no one can get a grant for the same invention globally. But if you
Okay,
have
sir.
filed a
Okay.
patent and if it is still not published, in between someone can get a patent.
Sir,
Any other-
until my patent get published, I cannot use or sell my product.
Until you file a patent, you should not sell your product.
Okay,
Filing is
until the
important.
filing. Okay, okay.
Registration, nahi, it's okay. You can start your
Sir,
activity.
like that for trademark, we are using TM plus. That same the pattern also.
There is no
We
something like
need.
that. You have to mention patented or patent applied or patent pending.
Okay, sir. Okay, okay. Sir,
Patented when it
can I
is
get
granted.
your number?
We will get you connected, Mr. Shafiji. Just we'll get the session ended. I told you we'll get you connected with him. We'll share his
Okay.
number and you can talk to him later, right?
Okay, I'm okay. Yeah, okay.
So on behalf of all my participants, I would like to thank you and also would really like to compliment you for your composedness and calmness. Like I've really learned today. You
Okay.
have mastered in like giving a training from making such a complex questions in just so simple, and you have been so calm and you have answered everybody's questions. I think I have also learned a lot today from this seminar because it wasn't only simple, but it has become so engaging and like not from the field itself, but I was there present all the while listening that I have also got so much information from you today.
Great.
Really, thank you so much. And on behalf of my team and the entire participants, I'm sure the way you have answered, your presentation skills, and everything has made us to stand out of the crowd today. They can answer anything on themselves, like so much knowledge you have shared with them, and nobody is stoppable from anything. They can just go and this subject only was looking so difficult, but really you have made it so engaging. Really, really, thank you so much, and we are really grateful you joined us. And I would like to thank each and every one of you who've been part of the seminar. So please write down on your comments how did you find the seminar and the session, and if there's anything else you want us to do to make you better. And thank you on behalf of each one of us, so we can have some more powerful sessions like this, because we really strive to get you the best from everywhere. Like Suniji has joined us today from Maharashtra. So thank you so much, sir. Thank you. Thank you, each one of you. Thank you.
Thank you. Have a nice day ahead. Thank
You too, sir. Thank you.